Hi, I'm Tom Klotz from the Federal Trade Commission. We're here to talk to Tom Leary, who's currently at Hogan and Hartson, about his background and experiences in antitrust. Tom, would you please tell us about your personal background?
Sure. There was no one in my immediate family that was a lawyer. But when I was a kid, I talked all the time and I argued all the time. And people used to say, from as long as I can remember, you ought to be a lawyer. So I had it sort of in the back of my mind, but I wasn't a burning vocation or anything like that. And when I was in my final year in college, the Korean War was on, and we all felt that we'd be in the military sooner or later, one way or the other. It was universal conscription in those days. And I decided I wanted to become a naval officer, so I applied to OCS to get myself trained up there to be a naval officer, but as a kind of a reserve, I applied to a couple of law schools, specifically Harvard and Columbia, and I was accepted. And then the Navy thing came through, and I wrote to both of those schools and said, I'm going to be gone for 3 years. I may be back in touch with you when it's over. And so my first career choice was really to go in the military, but I was holding it in reserve, and I didn't know what I was going to do. And then about 3 years passed, and by this time I am married. I was an air intelligence officer in my fighter squadron in the Navy. I was very much interested in intelligence work. I was being recruited by the CIA, and I thought very seriously about going to work for the CIA. And at that time on the ship, we were in the South China Sea, and my two roommates were lawyers, and they were country lawyers from the South. And somehow or other, in the course of an evening's conversation, I allowed that I'd been admitted to Harvard Law School. And they said, you've been admitted to Harvard Law School and you're not going to go? You're even stupider than we thought you were. And they beat up on me and they beat up on me. And I made that decision. That night, I made the decision, okay, when I get out of here, I'm going to go to law school. And it took a little doing because my service in the Navy was due to expire in October, and I had to get out a few months early in order to go up to Harvard in the fall of '55. But the war was over. The military were letting people out early if they had a good reason for it. And so I got up the next morning and I wrote a letter to the Navy, and I asked to be released early. And I wrote a letter to Harvard, and I said I'd like to come up. And I wrote a letter to my wife, and I said, guess what I've decided to do? And I wrote a letter to my father to discuss certain financial matters. And I had to wait a month for the replies. They didn't have email in those days. And a month later, Harvard said, come on up. The Navy said, we'll let you out early. My wife said, sounds okay to me. And my father said, I'll pay for it. And that's how I got to be a lawyer.
Now, when you went to Harvard, were you immediately drawn to antitrust, or were you
No, actually, I
areas?
wasn't. I took an antitrust course, but I took the long course there. There was a one-year antitrust course that was taught by Don Turner, and I took a shorter course that was taught by a man named Kingman Brewster, later became president of Yale. And but that was considered the kind of the quick pass, and I didn't have any idea I wanted to be an antitrust lawyer. I wanted to be a litigator. I wanted to be an advocate. I did not want to be a transactional lawyer, but that was the distinction in my mind. And I wasn't really thinking about antitrust as opposed to any other discipline.
Okay, so then after law school, you went to White & Case?
Right.
How did you end up in antitrust? Did you do it through litigation or through other ways?
Well, the first case I was assigned to, by the luck of the draw, was an antitrust case, and it was a case that ultimately made its way up to the Supreme Court. It involved a government challenge against W.R. Grace and Pan American and their jointly owned airline, Panagra, in South America. And we had kind of the small part of the case, which was defending Panagra. And because it was a small part of the case, I was the only associate working on the case. I got to write the brief, I got to select the exhibits, and I was kind of second chair at the trial, and it was a tremendous experience for me, and I was really excited about it. And in the course of that, I had what was one of those wonderful moments that comes to probably a law firm associate once in a lifetime, and it happened to me in my first case. I'll tell you about it because I've never forgotten it. One of the charges in the case was that Panagra had attempted to monopolize air transportation in South America. And they were a little bit, you think, well, what's the relationship to U.S. commerce? People were a little fuzzy about those things in those days. They didn't pay that much attention to them. And they had bought up a lot of competing airlines. Our client had bought up a lot of competing airlines in South America. And I'm doing the file search all by myself, nobody else. And I was down in the basement of some office building with one bare light bulb and dust all over the place. I had to step out every 20 minutes or so to get my breath. It was just god-awful down there. And reviewing all these musty old files that nobody had looked at for years and years and years. And there was a letter in there addressed to the CEO of Panagra from one Alan Dulles, who in the 50s, of course, was head of the CIA, but he was some official in the State Department in the 1930s. And he was writing to Panagra expressing the gratitude of the United States for their efforts in support of the denazification program, because all of these airlines were owned by German nationals, and the United States was very much concerned about Nazi Germany having a foothold in South America. And Panagra was acting at the behest of the U.S. Department of State when they bought up all those airlines. Well, that little piece of paper, as you can imagine, was the crown jewel in our defense, and I found it at the bottom of, everybody had long since forgotten about it, and I've never, ever had an experience to match it in finding the magic bullet in a discovery in an antitrust case. So that suckered me in. It really made a big difference to me. And then the next case, it was another antitrust case, came up, and people, I didn't realize I was making a career choice, but people said, well, you know, are you willing to take on another antitrust case? And I said, sure. I was having a good time. And then I had a second one, and then a third one. And then by that time, you all of a sudden acquire sort of an identification in the firm as an antitrust lawyer. I still did a lot of other stuff, which I had that identification as an antitrust lawyer. And so just like I backed into the professional law in the first place, I kind of backed in it by accident.
A lot of this progression of cases, which were some of the more interesting or cases that you remember most?
Well, while I was at White & Case, the most interesting case that I worked on, I guess the most significant one, although it was frustrating in many ways, was the electrical litigation. And as you probably know, in the late 50s, there were 19 indictments for price fixing in the electrical industry. And because the customers were public utilities that had a very keen public obligation to sue, that spawned 3,000 antitrust cases across the United States. And this was before they had the judicial apparatus in place for handling mass litigation. And so the judges were making it up as they went along in the course of that case. And I was right in the middle of it because my then firm, White & Case, represented the General Electric Company in the big turbine cases in New York. And they were the big dollar cases and the thing. So we were kind of the bellwether. And we were right in the middle of it. I can remember the managing clerk in the law firm who was responsible, you know, for logging all the new, walking into my office day after day with a stack of antitrust complaints this high and saying, here are the ones that came in yesterday. And so it was exciting in a way because I felt I was being part of antitrust history. It was ultimately frustrating in some ways because we knew that in the long run, it was like having a fatal disease, because we knew in the long run that our client and the other clients were going to have to cough up big money, big time, and they did. They had record settlements in those cases. So it was, on the other hand, I learned an awful lot. And I'll give you one anecdote from it that may be of some interest to people. Part of my job was to, I call it babysit, the various price fixers who were going to be witnesses for the client. And these guys had long since, some of them had been to jail, they'd all been fired, a lot of them were very surly, and they'd come in for their depositions. And my job was basically to stay with them all the time in case in some off moment they came up with something that might be useful. So I essentially was living in hotel suites at the time with these guys and going to breakfast, lunch, and dinner with them and so on and so forth. And I remember very vividly talking to one of them at one time, and this guy had been indicted, he'd gone to jail, he'd gotten fired, his life had been ruined. And I asked him, I guess we were having a bibulous moment, and I asked him, well, what did he learn from all this experience? And he said to me, what I learned is never talk prices with more than one guy in the room. And you wonder in subsequent years why I've been so down on 3-2 mergers and why they are so significant. It's not just because of a lot of fancy economics, it's because I believed on the basis of that discussion and others I've had, that the risks of illegal collusion are magnified by several orders of magnitude if there are only two people or two companies.
Were there other cases that you worked on at White & Case that?
Well, there were. I worked on a couple of cases in the Federal Trade Commission that were historic. The FTC in those days did all its work in Part 3 in antitrust because they didn't have the 13B authority to go into court directly. So everything was an administrative trial. I don't know how many administrative law judges there were. There were probably a dozen. And at one time, and I remember I was 3 or 4 years in, 3 or 4 years in as an associate, I was working simultaneously on 5 Part 3 trials in the Federal Trade Commission. One of them was for Foremost Dairies, and it was the Foremost Dairies merger case, which became sort of the poster child for idiotic antitrust enforcement later on, because the essence of the FTC's complaint was that these mergers were bad because it would make the combined entity too efficient, and it would be very hard for the smaller dairies to compete with them. And that was the mantra for that was, decisive competitive advantage. That was a bad thing. And I can remember even then being aware that there's something very odd about having to defend a merger case by claiming that whatever we may have said in an annual report or internal documents, we wouldn't dream of becoming more efficient, which seemed pretty stupid to me at the time, but that was the way the law was enforced. And so I remember that one quite vividly.
Now, you left White & Case and you went to General Motors.
That's correct.
What were some of the more interesting matters that you worked on
Well, I
with
went to General
Motors?
to become a chief antitrust lawyer for General Motors, and I was then just rounding on 40 years old, I guess. General Motors was everybody's favorite antitrust target, and they were so much in the public eye that the Department of Justice had a special antitrust section that did nothing but investigate General Motors. They called it the General Motors section in the antitrust division. And the Federal Trade Commission was riding herd on us all the time as well. So I guess the most interesting aspect of it was not a single case, but the fact that the company was operating under intense prosecutorial scrutiny at all times. And as a result, every major decision that the company made was subject to antitrust review. And so I felt that I was kind of right in the middle of the action at that time. At one time we had, in addition to myself, I had 18 full-time antitrust lawyers practicing antitrust law exclusively in General Motors, along with a few others that were doing other kinds of stuff that had passing interest in antitrust. So it was the big legal activity for the company at that time. You know how many antitrust lawyers they got now on the staff?
Honestly, I do not. Okay.
One. Because they're nobody's antitrust target anymore.
Now, when they are everyone's antitrust target, was that what motivated you to get involved with the Economists?
Well, that's a very interesting story. In many ways, General Motors was sort of the godfather of what came to be known as, at that time they called it the New Learning. Later on, they've referred to it more frequently as Chicago School Antitrust or some variant of it. But that notion that was prevalent in the 1960s and early 1970s that I referred to, that big was bad, efficiency was bad.
So you're carrying forward that discomfort with the decisions in foremost areas.
Well, sure, and that was the way the antitrust laws were enforced. Well, General Motors, obviously, that was unpalatable to them as the largest and most successful company in the history of the world at that time. And there was a growing rebellion in the academy against that philosophy and the emergence of the notion that efficiency was good, that being big was not necessarily bad, that hard competition was desirable rather than soft competition, and so on. That was bubbling. That was bubbling in the academic arena, and every single one of the economists who became identified with that new learning was spotted, and their research was supported by General Motors Corporation. Doesn't mean that General Motors supported them and they altered their views. It means that General Motors looked for the people that had congenial views and saw to it that they had the opportunity to do their work. And so every one of those guys, you think of people, well, Bob works on The Economist, but he was the one who conveyed that antitrust learning to the bar at large. But you think of people like John McGee and Harold Demsetz and Yale Brosen. Every single one of those people I got to know and worked with very closely. And that was an intellectual eye-opener for me. And that activity ultimately, as you know, a few years later bore fruit in the Supreme Court. And I always marked the turning point as the Sylvania case in 1977,
right,
when new learning was essentially accepted by the Supreme Court. And all of the economic arguments that we think of today in the Sylvania case did not come from the briefs of the parties. It came from an amicus brief filed by the American Automobile Association, and that brief was drafted by the General Motors legal staff. So I've always felt that I had at least a small personal role in seeing that those arguments were accepted by the Supreme Court. Now, as it turned out, when I later went into private practice in the 80s, it didn't look like it was such a smart thing to be associated with, because it had an immediate impact of reducing the impact and the importance of antitrust, and it probably cut into my income considerably.
When you were at General Motors, you also worked on the joint venture with Toyota.
Oh yeah,
which was
yeah.
certainly
I worked
one of
on
the more prominent.
I worked on the on the GM Toyota joint venture, and I remember that very vividly. I was the I didn't have, by the time it was attacked in the Federal Trade Commission and they had to arrive at a decree and so on, I was gone. But I was the one who was essentially responsible for structuring it before I left. It was the last thing I did. of any importance before I left General Motors at the end of 1982.
When you left General Motors, you moved on to Hogan and Hartson.
I went down to Hogan and Hartson. That's a funny story, too. You know, all the big decisions in my life, I always am kind of overawed by these people who have charted a career path and have decided, that, you know, I'm going to do this, and I'm going to do this, and I'm going to do this. And that's never been the way my life is. I've had just a whole series of things come up, and they look good, and I've taken advantage of them. And what happened was, I was on the council of the ABA at that time. This would be 1982, 25 years ago. And I got a call from a headhunter asking me, saying he represented some unnamed major Washington law firm, and was asking me for a recommendation of names prominent in the antitrust section of people who might be interested in becoming the head of the antitrust practice in this particular law firm, unnamed, which that's fairly standard. And so I gave him a few names, and I started asking some questions about it. And by this time, the antitrust involvement in General Motors was beginning to decline. The company was losing money hand over fist, and the antitrust agencies were not all that interested in General Motors anymore. And I was thinking of making a move anyway. And the more I talked to him, I said, you know, I might be interested in that myself. He said, well, you would? I said, sure. And so I came down to Washington and started meeting with a bunch of people, and that's how I went to Hogan and Hartson. Again, I don't know, fortuitousness. That's continued in my life too, by the way. We get to it later on.
Now, what were some of the more interesting matters that you encountered at Hogan and Hartson, or particular clients that you were taking on?
There are two things that stand out in my memory about Hogan and Hartson, and at least my initial exposure there. One was a continuation of work that I had started doing in the 70s, and this is by this time I am in 1982. I was 51 years old, and I was no longer that active as a trial lawyer. I really didn't think of myself as a trial lawyer anymore. I thought of myself more as a counselor and an advocate on paper, either in court or before a government agency. And we had done, when I was at General Motors, we were very much interested in public policy, not just antitrust, but supporting free market policies across the economy. And I was privileged, actually, to the chairman of the board in the late 70s of General Motors, a fellow named Tom Murphy, was very active as a very prominent CEO, very active in speaking on these subjects and signing op-ed pieces in various newspapers and so on. And I wrote most of that stuff for him. And so I was very immersed in that, and I did a great deal of advocacy up on the Hill. I've never thought of myself as a lobbyist, as someone who hung out with politicians, but someone else would open the door, and I would be brought in to talk about the substance. And that activity, I did a lot of that in the 70s while I was at General Motors on behalf of the Business Roundtable, because Tom Murphy was the chairman of the Business Roundtable. And when I came down to Hogan and Hartson, the very first client that I brought into the firm was the Business Roundtable to handle their antitrust work, both advisory and up on the Hill. And I was involved either at GM or at Hogan and Hartson in legislative battles going all the way back to Hart-Scott-Rodino. Well, again, I know we're going to talk about those a little bit later, but there were a whole series of them. And that continued through the 80s while I was at Hogan and Hartson. I did a lot of legislative work at Hogan and Hartson, and particularly in the 80s when there were a lot of high visibility fights up there on the Hill. In addition to that, by this time, the antitrust practice in D.C. in particular had evolved very heavily into a merger practice. advising on mergers and defending mergers in the two antitrust agencies. And I started doing a great deal of that.
In 1999, you left Hogan and Hartson when you were
Correct.
appointed a commissioner at the Federal Trade Commission.
Yeah, another accident.
Another accident happened.
Another accident. I was not thinking or planning to go to work for the Federal Trade Commission. It was by that in 1999 I was 68, and I was beginning to slow down. I was beginning to tail off as an active lawyer. And Christine Varney, who was at that time a partner in Hogan and Hartson, but who had served on the Federal Trade Commission, came up to me and she said, there's a Republican seat open. Mary Esquinaga's term is going to expire in June of 98. This was June of 98. And she said, would you be interested in putting your hat in the ring? And I said, are you serious? I haven't given any thought to this. And I don't know anybody up on Capitol Hill anymore. And I never did become personally acquainted with politicians. And I said, I don't. Well, she said, Bob Potofsky wants to know, because he thinks it would be great if you could get on the Federal Trade Commission with him, and we'd known each other for years. And she said, why don't you have lunch with him? So I went down, I had lunch with Bob Potofsky, probably at the 701 across the street, and he ate there all the time. And he made this big pitch to me, and he said, well, why don't you have a shot at it? He said, you've got to get the Republican leadership to propose you to President Clinton, but I'll take care of the White House if you can get that done. So I went, and I had some good friends in the firm who were very close to the Republican leadership. Bob Michael, who had been the Republican leader in the House of Representatives, was at Hogan and Hartson, a very good friend of mine. Frank Fahrenkopf, who'd been the chairman of the Republican National Committee in the late 80s, was a very good friend of mine. So I talked to those guys, and I said, you think you can get the Republican leadership to request the president to nominate me? And they said, well, I'm going to try. And I didn't give it a great deal of thought. Honestly, that's about all the work that I did to get that nomination. And the next thing I know, did I tell you this story?
Yeah.
Well, it was really bizarre. I'd really forgotten about it largely, frankly. I didn't hear anything, and I got a call from a secretary or an appointment, a woman in Trent Lott's office who was responsible for his patronage appointments. And she called me up and she said, Senator Lott wants to recommend you for the Federal Trade Commission seat. And I said, huh? And she said, well, I'm sitting here and we've got 350 letters recommending you. And because some of my friends, I've got some good friends, I'd made a lot of friends in the antitrust bar, and among the people were every living former chairman of the antitrust law section, had jointly written a letter and so on. So I said, well, gee, this is great. Does the senator want to see me? I never met the man in my life, and I never have, by the way, never have met him. And she said, no, you've been recommended by people he trusts. It's fine. That's fine with him. So that's how it happened. That's really, honestly, how it happened. And so if you say one more time, I stumbled into something, well, that's the fact. That's the fact.
So you became a commissioner in 1999.
That's correct.
What
It
were
took a
some
while for reasons that you understand. Well,
And
you know
you
what
wanted-
happened. And you know what happened in the middle of 1998 that put everything in the White House on slow motion, which was a certain young woman that was in the news.
Certainly.
Yeah,
So you became a commissioner in 1999.
that's correct.
At the commission, what matters stand out in your mind as the ones that you either enjoyed or you feel are particularly important?
The one thing that I enjoyed more than anything else, this isn't a matter, this is an atmosphere. the one thing that I enjoyed more than anything else was the ability for the first time in my life to work on my agenda. As a practicing lawyer, and I'd had wonderful clients, and every single company I represented, I have warm feelings for. I never had to do anything that really left a raw taste in my mouth, and I think we'll get to that later on. But at the same time, when you're a lawyer, what we do is work on someone else's agenda. Client's agenda is our agenda. Our job is to do what, to the extent we can, within the system, to advance what the client wants to do. And this was the first time in my life, in over 40 years as a lawyer, when I had the opportunity to do exactly what I wanted to do. I didn't report to anybody. And that was exhilarating. That was exhilarating. My only boss was my own conscience, and the Constitution and the statutes and a few things like that. But it was liberating. It was tremendous. The associations with my peers. I served with, I can't count, I guess, at least 8, a large number of other commissioners and their various offices. I enjoyed working with every single one of them. I'm become a great believer in the collegial process. It can be a little bit inefficient sometimes. It takes a little bit longer sometimes to arrive at decisions, but I firmly believe that we arrive at better ones as a result of having a commission with appointees with different political philosophies and with different backgrounds and bring different perspectives. I'm a great fan of it. I love that. I had wonderful advisors, by the way. You know, he was one of my advisors, and I had terrific, I enjoyed it. And as you well know, we had no ideological uniformity in my office. We used to argue vigorously with one another on a daily basis, and I loved that part. I found that was exhilarating. We had some very exciting, I mean, the biggest case that we had, and in many ways the most challenging, because of the complexity and the size, was the AOL Time Warner matter, which I think was the largest merger in history up to that time. It may not be now. You probably remember that very well.
There was a lot of agonizing over that case.
A lot of agonizing over that case. My recollection is we had typically, as you know, we have one commission meeting to consider a matter and vote it. AOL Time Warner, we had at least 3. Because there were so many different aspects of it and so many things. And you may remember the floods of people coming into the office with various eminent people coming in who were interested in it. And the humbling part about it is that we had that decree, and a very complicated decree that was negotiated over an extensive period of time, and we agonized over. And just about everything that we feared would happen didn't turn out to be true.
We're still waiting to see interactive television.
We're still waiting to see interactive television, which exhilarated a lot of people and scared a lot of people. But, you know, there's no reason for us to feel bad about that, because all the business folks were dead wrong about it as well. So we weren't alone. But one of the lessons you learn from something like that is a lot of times something a consequence that you fear is going to occur, it proves it just won't happen. But that one was exciting. The do not call was fun. And that was high risk. You know, a lot of people don't realize that, because that turned out to be the most popular thing that the Federal Trade Commission ever did. And a lot of people may think, well, it's a no-brainer that, you know, once someone's thought of it, gee, it's such a great idea. But the fact is it was high risk, and we were very worried about it, because if there had been massive non-compliance with that do not call rule, which now has 130 million plus numbers on it, if there'd been massive non-compliance, where the Federal Trade Commission would not have had the resources to deal with it, and we would have wound up with egg on our face looking stupid. And there was a lot of concern about that. There was a lot of concern that the rush of people to sign up, and I don't know how many we had, something like, I don't know, 20, 30 million in the first week, would swamp the system, and we'd wind up with egg on our face. And so it was high risk, but it was exciting to be part of that. I enjoyed the privacy arguments, and do not call was and I give Tim Muir's credit for this. Basically what he did was segue the privacy debate away from collection of personal information, which was a really difficult issue and highly controversial, into privacy in your own home and freedom from intrusion in your own home, which do not call represented. And I thought that was a stroke of political genius, quite frankly, and I applaud him for it. Then, those are things that were fun to remember. Then there is a certain matter that you are as familiar with as anyone else that's painful to remember, and that's the extended consideration we gave to the sharing case and the generic settlements, which is still a controversial issue and which has still not been resolved. That was a painful loss. That was a painful loss. And if you asked me what was maybe the biggest disappointment I ever had in my life, it was to see all that work that we had done, and you'd probably worked harder on it than I had, just go up in a puff of smoke in an opinion that I might say was written within a month and that was, to put it mildly, cursory and disrespectful. Still rankles. Still rankles.
On that front, I'm sure you're not alone.
Yeah, I guess not. Yeah.
When your term expired, you returned to Hogan and Hartson.
I did.
And how has your role changed with this trip around compared to the earlier time at Hogan?
Well, when I talked to them about coming back, they said, "Do you want us to call you a partner?" And I said, "No, sir. I don't want to convey the impression that I have that level of availability." And I said, "You call me of counsel," which is what I am. I said, "I don't want to be really in charge of anything anymore. I want to be a resource. I will keep track of my hours because you're going to need them to bill clients for me, but don't expect me to worry about them. And I refuse to look at any statistical data on my performance or anybody else's. I'm not interested in anything having to do with the business management of the firm." And I pleaded my years. I said, "You reach a point in your life when you just don't care about those things anymore," and I don't. And I said, "Pay me whatever you think I'm worth." And that's my deal.
Sounds like a pretty good deal.
Well, it's fine. It's fine with me. I'm doing it because I enjoy it.
You earlier talked about your client, the Business Roundtable, and
Right.
you were doing some lobbying efforts with them. Why
Right.
don't we talk about a couple of those?
Sure.
You mentioned the pre-merger notification.
Yes.
What were the arguments on each side, and have all of those fears materialized, and
No,
how have things changed now that we do have the Hart-Scott Act?
Yeah, that's a fascinating story. The argument in favor of pre-merger notification was, as you know, that you remember the term midnight mergers, that people would even if a merger was under some kind of an investigation, there was no way to stop it without going into court, and the parties could close. And it's very, very difficult to unscramble the eggs. The history is that once companies are bonded together, it's very, very difficult to unscramble them. And so that was the argument in favor of pre-merger notification. The argument against it was that, bear in mind that this statute was passed toward the end, but still in the middle of a period when there was a perception that the agencies were extremely hostile to size and efficiency. And there was a fear that process, delay, and burden would be used to achieve a substantive result, which was to chill mergers unduly. And that was the big fear. And that, I acknowledged, 30 years ago, proved not to be true. That fear was just another one of the fears that was dead wrong. Because what happened was that the agencies got used to looking at mergers in an educational environment rather than an adversarial environment. They approached the merger review process without the prosecutorial mentality, but approached it, well, they wanted to be educated on what was going on in the industry. And I think what happened was because it's, think of the analogy of a doctor that deals with sick people may get the impression that there's a lot more sickness in our society than is justified. But if you have a doctor who's just doing routine examinations of an awful lot of healthy people and sick people, they have a more balanced view. And that's what happened to the agencies, because the vast majority of the mergers they looked at were benign, but simply had to be reported because of their size. They got used to thinking that there were a lot of benign mergers out there. And I think it was a major contributor, ironically, a major contributor toward the greater receptivity in the agencies of pro-merger arguments.
You also were involved with lobbying with respect to Illinois BRIC and some of the repealer statutes.
Yeah, Illinois BRIC was decided in 77 or 78. There was an immediate effort in Congress to overturn the decision, which we vigorously opposed and which the Roundtable and a lot of the other business organizations vigorously opposed. Ultimately, we were successful. Then we started having to beat off the initiatives in the states. By the time our Roundtable client had woken up to it, the laws had been passed in about 10 states. And we set up an operation to deal with state laws. And dealing in the state legislative arena is something that I'd never had any experience with. It's very, very different because in most cases, laws at the federal level, they take a long time to ripen. A state law, can be passed in the blink of an eye, really. Before anybody's really had a chance to focus on it. They don't have necessarily that protracted hearing process. So what we had to do in all of the states where they hadn't already passed a law, why we would hire a local law firm that may have their office across the street from the State House. And their job was to look for anything looking like an Illinois BRIC repealer. And then we had prepared lobbying materials and Q's and A's and witnesses available to come in and argue the merits of this literally at a moment's notice. And we fended off 10 in a row. And then for reasons that, like any business group, they don't have an unlimited ability to respond to every fire. And there were other matters that got higher priority within the organization. And as a result, that effort kind of fell away. And as you know, I think the majority of states now have Illinois BRIC indirect purchaser lawsuits. And it's a shame because it's led to, as you know from reading the AMC report and everything, it's a very difficult and controversial issue now.
And one last one I know you worked on was the R&D joint venture.
R&D joint venture, yeah, and that's another one where we guessed wrong, really. The objective there was objective of Congress, which we supported, was to encourage businesses to engage in R&D and later manufacturing joint ventures, which are marriages of temporary nature, and they are not comprehensive, and they have fewer competitive effects than a merger. And we were hoping, frankly, to nudge the business community in that direction, and it has proved not to be the case. As a matter of fact, nobody even thinks about those statutes anymore. They were designed to encourage activity, and it didn't work, and for a whole variety of reasons that are worth a speech on its own. That was sort of a disappointment that they didn't use it. And the reason, by the way, as you know, my background in working on those laws is the reason why, when I was on the commission, I tended to be very hawkish on the issue of merger specificity. When the parties would come in and say the merger is going to create efficiencies, I always wanted to know why there wasn't a less restrictive way to achieve those efficiencies. And that was, I think, that inquiry was stimulated by my work on the research joint venture bills.
Those are your past instances of thinking about antitrust policy. What are some of the biggest challenges in antitrust today?
Well, the ones that everybody thinks about is of course the growth of antitrust regimes all around the world, and the possibility of inconsistent results, and at least the possibility or the reality of burdensome duplicate filings here, there, and everywhere. But I don't think that ultimately is the biggest challenge. I think, as you know, and as some of the things we talked about, I think the biggest challenge for antitrust today is a fundamental economic one, because I still believe that the roots of antitrust are economic, and I do not believe that we understand much about the economics of businesses that are characterized by a high level of variety and individual consumer appeal. And we're becoming more and more a society where various products, services, and experiences are going to be tailored to you individually. And how do you deal with that? What are the appropriate markets? How do you measure performance? You can't say, you know, that the economists used to be able to say that an industry characterized by high profitability and so on wasn't performing well. You can't say that anymore. And how are we going to deal? How are we going to deal with what I call the Harry Potter world? I don't think that anybody really knows yet. I don't think we've got rigorous tools or rigorous ways to analyze those things. And I think that's a tremendous challenge. It's an intellectual challenge, and one that's going to require not just a bunch of lawyers, but a bunch of academics to try to figure it out.
That's the questions. Then what are the important lessons you've learned, and what's the advice you would offer to young attorneys?
The biggest lesson I've learned in life, and I've illustrated it with a few examples, is that I am frequently wrong, despite my best efforts to do the best job I can to scope something out. And the longer I live, the more memories I have of being wrong. I have been wrong in my life a lot more often than you have. And that therefore the only response to that is appropriate is, with increasing age and experience, to be a great deal more modest and humble about your own conclusions.
Thank you very much, Tom.